Good morning, Mr. Owens. You will recall the, I hope, helpful suggestions about watching the time. You may proceed.
If it pleases the court, my name is Roy Owens. Today I'd like to argue fair play and the abuse of process. On May the 17th, 2004, I was suspended from my job, and on June the 6th, I was terminated. As a result, I filed a brief with MCAD. Following that, I filed a recommendation from the Massachusetts Equal Employment Opportunity to file a case with the Superior Court. I filed on June the 20th, not June 20th, excuse me, February 20th, 2007, I filed for a complaint against the City of Boston, the Commonwealth of Massachusetts, the Boston Public Schools, and the Boston Teachers Union. The defendants did not return the complaint answered. So therefore, I filed a default against the City of Boston, the Boston Public School, the Massachusetts Education Department, and the Teachers Union. The default was issued, but in the meantime, the defendant came into court and asked the court for a date, a hearing. The court suspended, I received a default in the mail, but the court said they requested a set aside. The court took it under advisement. They filed for a hearing on April, and the court set a hearing date in May. The court took it under advisement. And the court, through the process, set aside their default, although the only person that responded to the default and asked for the request was the City of Boston. The rest of the defendant never applied, nor asked for it, but the court gave them, removed all defaults. The court, the defendant then asked for that the court have me to redo the complaint. Again, I served the complaint in September. The defendants again defaulted. I asked the court for a default against all defendants. The court refused to default. So I'm asking that according to the law, they have 20 days in which to respond to plaintiff's request. And the law say that they must be defaulted. That's according to the law. It says defendant has 20 days after the service of summons and complaint. And then it says, if you fail to do so, judgment by default will be taken. The court has continuously refused to give me a default to Superior Court. But on the other hand, in 2001, I filed a case against the Commonwealth. And again, they defaulted in that case. And the court refused to give me a default. But they claimed they sent me an 9A. And within 2 days of submitting that to the Commonwealth submitted to Superior Court, they defaulted me and refused to remove the default. That case was went against me. They refused it. I appealed it in the appeals court, and appeals court upheld, say that I didn't answer the 9A in time. I also appealed it, I believe, to the Supreme Court, and they just upheld it, said, well, you didn't respond in time. Here's a situation where it's clearly an abuse of the process, where they went over, not only didn't even, after more than 30 days, a month, the court continues to allow them to remove the default. And on the other hand, when they didn't allow the same to me. Today, the Commonwealth will also be arguing that there's a statute of limitation that they not only should not be defaulted, but they should not have been included in there because of time presentment. My argument is that when I was terminated, on June the 11th, and I filed for the complaint against the Commonwealth and the City of Boston, and against the teachers union and against the school committee, is that because, well, basically because the Commonwealth of Massachusetts. I filed it because they are the overseers for the City of Boston. I have put in an application for rehiring. Since then, they said that I didn't pass the teacher's test. I referenced in this application in my complaint that I had taken the teacher's test in 1998, and that according to what they said, that if you took the first two tests in 1998, then it was sufficient to pass the teacher's test. So therefore, they're claiming that I cannot be rehired because I haven't fulfilled the requirement for the teacher's test. I say that is wrong, and that's not an open, and it's not saying that I'm trying to reopen the case that I had filed against them in 2001. Not trying to reopen that case. What I'm saying to them is that I passed according to, and I submitted here in T1 and S1. T1, this is S1, and it reads this way. This is a letter from the commissioner of the Commonwealth of Massachusetts, and he says to me that test was mailed to the applicant's candidate on March 24th prior to Driscoll a letter. All candidates were advised that participating in the first two administrative tests would satisfy the requirement. As you are aware now, the policy was reversed. It was reversed after the Commonwealth had the deadline date to submit applications without having to take the test was February the 21st, 1998. The letter of reverse was not done until March the 24th. They had sent a letter. They had given everyone a letter stating that you didn't have to, that there were, whatever, that they wanted people to take future teachers to, they needed people to take the test. So they was asking that people would not file before February 21st, because where you filed before or after, you still would be given credit for passing the test. So it really didn't matter.
Mr. Owens,
Yes.
may I ask you a question? As I understand it, the City of Boston was defaulted. They moved to have the default removed, and that was granted.
That was granted, and the court removed all defaults.
Right.
They
Right.
removed for
No,
all
I understand that.
without making the request.
And has the city, perhaps I can ask the city's attorney, has the city filed a motion of dismissal on statute of limitations grounds?
No.
No, okay. So that case is still pending in the Superior Court? Yes.
Yes.
Okay.
That case.
I ask that, Mr. Owens, because generally speaking, you can only come to the Supreme Judicial Court while a case is still pending if there's some real emergency reason. And the claims that you are now talking about, I think you can make in the Superior Court.
The Commonwealth of Massachusetts, the court is dismissing the case against the Commonwealth.
I understand, but when the whole case comes up here, we will consider all of those claims. We don't take them up piecemeal. You with me?
Okay, I guess what I'm arguing is Commonwealth is saying that they are not receiving any information from me or the court because the court has dismissed them out of the case. So they're claiming they're out of the case, and it doesn't, even bringing the court case here doesn't apply to them.
Well, are you talking about the Commonwealth or the City of
The
Boston?
Commonwealth of Massachusetts.
Well,
They're
the
here.
Commonwealth is out
here.
of the case, as I understand it.
The Commonwealth is here.
I thought that the Commonwealth was out of the case. Maybe I misunderstand it.
That's the problem we're arguing, because they're claiming, the court is saying we're dismissing them, and they're arguing that it's time presentment. And my argument is, no, it's not, because it has no relationship to 1998, because it has to do with their oversight of the City of Boston and the teachers' testing.
I understand. But we will address that issue when it comes up here in the normal appeal, not on an emergency appeal.
Here's a question for the court. Then should they just let the case go forward and then get into all of the defaults and everything? Should they be answering to the court as the case is going forward now? Because I can't present, if I can't present the case against the Commonwealth, if they're not in it, and you're saying to just present everything here after, even though the case, you know what I'm saying?
And that sometimes happens, and then you go back, and if it turns out that the judge was wrong, then you get to try the case against the Commonwealth.
Wouldn't that cause us a lot of time and effort for everyone? I mean,
I think the answer to that question is likely yes, Mr. Owen, but that's what happens. What this proceeding is really for real emergencies that can't be taken care of in the normal appeal. Otherwise, everybody could come up.
Well, I guess the problem is I have here is that I'm out of a job. I haven't had a job since 2004, and they're claiming that in order for me to hold the case against the city of Boston, that the certification is the problem here, and they're claiming I don't have the city of Boston saying I don't have the certification, and the city of Boston is saying, well, the Commonwealth of Massachusetts is the one that does the certification, so therefore you don't have a case against us because this thing is really it's beyond us, and they're saying we're out of the case. So I mean, who am I pursuing the case against if I don't bring it now to say okay, to say that, because I don't. Where's the grounds?
Mr. Owens, this is what we'll do. You've made your argument extremely clear, for which I thank you. And as you know, we take it under advisement, and then we issue a judgment in due course. Yes. Thank you very much, Mr. Owens. Ms. Collins?
Good afternoon, Your Honors. Justice Cowan, just to answer your question, the Commonwealth is out of this case. That has currently been appealed. The appeals court has jurisdiction over that case at the moment. The Commonwealth's already filed its brief. As we understand it, the only issue before the court as to the Commonwealth here...
And has Mr. Owens filed a brief in that case? In the appeals court? Yes.
I'm actually covering this case for a colleague of mine. I believe
I'm just looking at your colleague. Your colleague is nodding, so I'll just take it.
Yes.
Okay.
The only issue here is whether the Superior Court judge properly was in his discretion to not default the Commonwealth. And we argue that the standard is abuse of discretion. And
and what was the explanation for why they did not default the Commonwealth?
The Commonwealth filed a motion to dismiss several days after the 20-day deadline with several meritorious defenses. And at oral argument, Justice Kratzley verbally denied Mr. Owens' motion.
Okay.
And unless the court has any questions of the Commonwealth, we will rest on our brief, being such a small issue.
Thank you, Ms. Collins.
All right.